All right, welcome everyone to the Judiciary Committee hearing this Tuesday morning, March 24, 9:45 a.m. in 016. If we have a catastrophic crash on the Zoom side, we'll try again on Friday, March 27 at 10:30 a.m. here in 016. For both people on Zoom, you'll be muted and your video turned off until it's your turn. And for everybody, a 2-minute time limit on testimony. Members often have questions, so if you can hang around after you've testified, that would be great. First up today is Governor's Message 573, submitting for consideration and confirmation to the statewide elections accessibility needs advisory committee. Gubernatorial nominee Luann Blake for a term to expire June 30, 2029. First up from Ms. Blake is, excuse me, Joel Cho in support, Patricia Morrissey in support, and Limke on Zoom meeting
No, Present Chair.
in support. Next is Katie Kime in support, Virgil Stennett in support, James Gashel in support, Deborah Gabe in support, Marie Kuthfood in support. That's everybody who signed up on GM 573. Would anyone else like to testify on GM 573? Okay, seeing none, members, no one to ask questions of. Ms. Blake, would you like to make an opening statement? Good morning.
Good morning. Thank you, Chair Rhodes and members of the Judiciary Committee. It's my privilege to be here. I am a blind voter, and I have had personal experience with many of the barriers that voters with print disabilities are faced with when they go to exercise their constitutional right to vote privately and independently. I have worked for 20 plus years as an advocate for the right of voters with print disabilities to vote privately and independently in a manner that is equal to the opportunity afforded to voters without disabilities as required by the Help America Vote Act and Title II of the ADA. I have also managed programming to provide training and technical assistance to elections officials at voting advocates in the protection and advocacy system, as well as to blind and low vision voters. And my advocacy efforts have been on a nationwide level. I am happy to say that here in Hawaii, I think things are more accessible for voters with print disabilities than they are in many states. I was really happy to be able to vote with a totally accessible vote by mail system in the 2024 primary and general election on my iPhone, which was truly thrilling. And Hawaii is only a handful of states where voters with print disabilities have that opportunity. While we are, doing a good job here in Hawaii, I think there are some areas where we could do some work on, where I would be privileged to work with the Office of Elections as a member of the statewide Elections Accessibility Needs Advisory Committee. I think we need to raise awareness among the print disability community here in Hawaii that this fully accessible system exists. I think we need to do more outreach. I think it would be great if the Office of Elections and members of the Accessibility Needs Advisory Committee could attend events such as the National Federation of the Blind of Hawaii annual convention, the Hawaii Association of the Blind annual convention, meetings of those organizations, as well as other meetings of other organizations that work with the print disability community here in Hawaii. It would be my honor to serve on this committee, and I look forward to working with the Office of Elections and the print disability community of Hawaii. And I'd be happy to answer any questions that anyone may have.
Great, thank you very much. Members, questions? Well, you pretty much answered all the questions I was going to ask. So I would just say, I think you mentioned before that you're already active with the National Federation of the Blind.
Yes.
So you'll have enough bandwidth to be able to do both that and this new responsibility.
Yeah, well, actually, my part-time job that I've been doing for the National Federation of the Blind of Hawaii as program manager for NFB Newsline Hawaii, I am actually retiring from that the end of April, so I will have lots of bandwidth.
Okay, sure. Well, I don't think I need to ask any other questions. Members, anything else? If not, let's go ahead and vote on this GM unless there's an objection, and we can let Ms. Blake go on her way. Recommendation is to advise and consent. Any questions or concerns? If not, Senator Gabbard for the vote.
On GM 573, Chair's recommendation is to advise and consent. Chair Rhodes?
Aye.
Vice Chair votes aye. Senator Chang?
Aye.
Senator San Buenaventura?
Aye.
Senator Owa? Excuse? The measure's adopted.
Thank you very much. Congratulations. There'll be a floor vote fairly soon. I don't know exactly when.
All right, mahalo. I really appreciate it.
Thank you. Okay, moving on to the bill portion of the agenda. First up is House Bill 2095. This is the judiciary budget for the fiscal biennium beginning. It's a supplemental budget. First up on 2095 is Brandon Kimura, Administrative Director of the Courts. Good morning. You don't have to say anything. I'm just, if you'd like to, go ahead.
Oh, sure. Just briefly.
Yes, of course.
Sure. Thank you. Good morning, Chair Rhodes, Vice Chair Gabbard, members of the committee, Brandon Kimura, Administrative Director of the Courts, and with me are administrators and subject matter experts from across the judiciary testifying strong support of this measure, which is our judiciary supplemental appropriations measure. We acknowledge the economic uncertainty facing the state, and yet respectfully make these requests due to the underlying circumstances of each of the requests. Overall, we're seeking $6.4 million in operating funds, and due to in 4 permanent positions, and due to conversion, subtraction of 3 general funded positions, and subtraction of 1 special fund position. We also initially request $55.4 million in bond funds. The House funded $45.4 million. We are agreeable with that approach on the bond fund front. We have requests in 3 general areas that I can describe or elaborate upon further later. First, in critical security resources related to first supplemental armed private security to supplement the services of DLE, a nuanced approach to 2 positions for cybersecurity. Second is the critical services to court users, specifically restoration of funding for POS contracts for substance use services in the First Circuit, and restoration of funding for the sole position for the Office of the Public Guardian on Kauai. And the third area is critical staffing resources, specifically requisite funds pursuant to the Commission on Salaries for FY27, conversion of 1 position from temp to perm, and restoration of funding for a position in Kona for court operations specialist, and no cost conversion of 2 temporary to permanent positions for the court for the CASA program on Oahu. Finally, for CIP, construction funds for South Kohala. And again, we're agreeable with the House's approach of 20 of the 30 requested million for phase 1, 1.2 million each for chillers on Kauai and Hilo, 15 million for Kahumanu Hale elevators, and 8 million in lump sum. So available for questions. Thank you.
Great. Thank you very much. Next is Hannah Lisiak for True Cost Coalition. I apologize if I butchered your name. Good morning.
Big Chair, thank you.
Good.
Good morning, Chair, Vice Chair, and members of the committee. My name is Hannah Lisiak, and I'm testifying on behalf of the True Cost Coalition in strong support of this measure. You have our written testimony, but just briefly, I wanted to highlight an appropriation of $574,716 within the judiciary's budget to restore funding for purchase of service contracts in the First Circuit Court that provide substance use treatment for adult probationers on Oahu. These contracts were significantly reduced during the pandemic, despite continued and growing need for these services. And restoring this funding is very critical for us. So I want to thank you for the opportunity to testify.
Thank you very much. Next is Nicole Wu for Hawaii Children Action Network Speaks. In support, next is Mark Murakami, Hawaii State Bar Association. Also in support, Thomas Farrell. In support, Sarah Fairchild. In support, and Jessica Hatcher in support. That's everybody who signed up on HB 2095. Would anyone else like to testify on HB 2095? Seeing none, members, questions? I do have a question for you, Mr. Kimura. So the lump sum request of 8 million for this is, I guess this is the second year in a row that you've asked for an $8 million lump sum. Is that correct?
I believe last year might have been 7, but it is, I can check that briefly.
Sort of larger than it's
Larger than
in-
usual,
in the
yes.
past. Is that how did the judiciary use that higher amount in this? Well, I guess the year that we're still in.
In the year that we're still in, well, both years, I should start back. The usual request is 5 million for lump sum to address, various projects across the state or to add on to a more specific CIP request. Last year, when I believe it was 7, it might have been 8. The additional from 5 to that higher number was specifically to address the Children's Justice Center. A year or two ago, the legislature appropriated funds to relocate the Children's Justice Center from Nu'uanu to a different site. We've since selected Leahi Hospital in that area. And as the plans are evolving and moving forward towards construction, which we hope will begin later or early this summer, we've working with DAGs identified additional funds necessary. So the 2 to 3 million that were added from last year's lump sum were towards that. And thankfully, we've actually have funds available in our lump sum to put towards that construction so they can put it out to bid again very soon. Because we've used more of the lump sum funds towards that project than perhaps initially planned, the additional 3 million this year from our usual 5 to the 8 million is to sort of backfill, if you will, our lump sum so that we can address a lot of those projects that we had planned on working on.
Okay, so the fact that the Children's Discovery Center got moved soaked up a bunch of
Yes,
money that you didn't expect, but now you're trying to catch up on the smaller. Okay.
correct.
So as you probably heard, there was a testifier for the True Cost Coalition. The idea being that the reimbursements for purchase service contracts aren't keeping up with inflation. Does the supplemental budget reflect an increase in those areas, or are the numbers essentially the same from last year?
It would be, in a sense, it would be an increase, but our budget request for 574 and change for substance use services on Oahu is relatively narrow in the sense of the True Cost Coalition, and we support their general efforts. It's for these particular contracts, which are probationers on Oahu. These funds were reduced significantly during the early part of the pandemic. And this is to bring us back to that pre-pandemic level. So this is not to the extent of the True Cost Coalition's efforts to expand and actually address the true cost of delivering services. We're happy and supportive of that. So long as we receive appropriations, we're happy to pass it through. But in light of the economic conditions of the state, our modest request to you at this point is the 574 to bring us back to pre-pandemic levels. And again, we would be happy to pass through more if more funding is available to the providers.
Okay. Are you concerned at all that you're going to stop? That some providers just aren't going to work for you anymore?
We do have significant concern, and that's a large part of why we're seeking to support the providers. with the decreased funding over the years from that pre-pandemic levels, and our, resultingly less funding for the contracts for the providers, we see that they have reduced their capacity and their stability. And we do, want to be able to support them. And so it supports not only the providers, it supports our clients, it supports the community, and it's a very economic use of funds.
Okay. So I'm assuming that that's not the only category of expenditures where inflation is having an effect. It looks to me like the elevators at Ka'ahumanu Hale are a lot more expensive than we thought they were going to be. Can you tell us what the status on that is at the moment?
Thank you, Chair. So the status on the elevators, on one hand, the elevators themselves are the same as they have been, which is in very poor condition. They continue to break down. People continue to get trapped. Judges and staff have been getting trapped, so we've had to postpone court hearings in that sense. So the elevators themselves are the same. In terms of the status of the project, we are continuing to work with DAGs. I've been in direct contact with the comptroller, who has reassured me that this is a high priority for them. They understand the circumstances and that these are unique elevators in the community of elevator issues that we all have. They plan to put out for bid soon, with the funding that has been previously appropriated, a project for all 9 elevators in the building. DAGS believes that of the funding that has been previously appropriated, that is sufficient for the first 5, and the funding that we are requesting this year would provide the funding for the remaining 4 elevators for the 9 in the building. DAGS is as a indicator of how much they're highlighting this as a high priority for them. They're taking an appropriate and fully legal but unusual measure of providing partial certification of the funding so that they can put it out to bid for all 9 elevators, even though at this point, as we sit here today, we only have the funds for the first 5.
Okay. So the 9, there's some public ones and some private ones. Is that correct?
Yes, there are 4 public elevators. 1 is a custody elevator and 4 private elevators.
Okay. Okay. Members, other questions? If not, thank you very much.
Thank
We'll
you.
go ahead and move on to the next bill. That would be HB 1520. This clarifies that the 5-year statute of limitation for criminal prosecutions of campaign finance violations begins upon discovery of the offense by the Campaign Spending Commission. First up on 1520 is Kristen Izumi Natal, or her designee. Oh, no, you're here. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, Senator San Buenaventura, Senator Chang, Kristen Izumi Nitao, Executive Director, Campaign Spending Commission. We are here in support of this bill by changing the start of the statute of limitations period from the date of violation or date of filing the report to the discovery of the violation by the commission. We believe that it will prevent candidate committees and non-candidate committees from delaying proper reporting on campaign finance reports to avoid prosecution. I would like to add, however, that with respect to Section 2, we would recommend the reinsertion of the language on, I think it's page 2, line 16 through 18 from the original House bill concerning reference to the statute of limitations for campaign spending violations to commence upon discovery of the offense. This is just for consistencies when matters are referred for criminal prosecution, because as you know, Section 2 refers to 701-108 and Section 1 refers to the campaign spending statute. I'm available if you have any questions.
Okay,
Thank you.
Next up is Marlene Tom for Indivisible Hawaii Statewide Network on Zoom, maybe.
Yes. Good morning. Good morning, Chair Rhodes, Vice Chair Gabbard, and members of the committee. Marlene Tom, on behalf of Indivisible Hawaii, thank you for this opportunity to testify in strong support of HB 1520, HD1. We support this bill because we believe that the current 5-year statute of limitations of criminal prosecutions of campaign finance violations is insufficient, or because campaign finance violations are often difficult to identify, and they're not immediately noticed. So it makes a lot more sense for the 5-year limitation to begin when the offense is discovered and not when it actually took place. We believe that by strengthening, excuse me, or adjusting when the 5-year statute of limitations begins, it strengthens the deterrent power, excuse me again, the deterrent power of our existing campaign finance laws, and ensures that accountability will take place when the crime is discovered. This will restore public confidence that our elections are fair and our officials are playing by the rules. Thank you for the opportunity. I hope you will advance this bill.
Thank you very much. Next up is Eileen Hilton for Windward Coalition. In support, Chris Caulfield for Emua Alliance. Also in support, Ann Frederick for Hawaii Alliance for Progressive Action. In support, Gregory Masakian on Zoom, maybe?
Not present, Chair.
Also in support. Okay, there's a list of quite a few people that are all in support. The total count was 26 in support, 0 opposed, and 0 comments. At this point, does anyone else wish to testify on HB 1520? If not, members' questions?
Yes,
Senator San Buenaventura.
Kristen. Wanna. So, my problem with this is there anything in the statutes that require campaign spending to use due diligence to find these violations?
I don't know if I see that specific verbiage, but
Okay. See, I do criminal defense before I became a legislator, and there are tolling statutes, right? If, for instance, the defendant chooses to leave the jurisdiction and then the statute of limitations is tolled, or if certain things don't occur, the statute of limitations are tolled. But in this instance, this bill, you don't have a tolling. You basically are allowing the campaign spending to take its time to find these violations. It could be like 20 years down the road, 20 years after the election. And to me, it doesn't do the public any justice because the election has come and gone. Whereas if the Campaign Spending Commission does its due diligence and points out the violation before the election, then the voters know whether or not these intentional violations occur. Okay, so would you be amenable, instead of a discovery, to allow for tolling provisions that says that if there's an intentional deception or words that effect, similar to the criminal statutes, but to still require campaign spending to use its due diligence to find these violations?
so Senator, a lot of these, the reason we're in support of this is we can only do so much as what is reported. And a lot of times we found out there's misreporting. And that's not on behalf of the Campaign Spending Commission. That is on behalf of the committee that has failed to disclose something that we have found out later on, typically maybe by a whistleblower, perhaps sometimes maybe by just looking at the other filings, but a lot of times we just have to rely on what is filed by the candidate or the non-candidate committee. And we don't find some of these things out till much later because sometimes there are amendments that occur or more information that comes out to light. So what this statute permits us to do is from the date of we discover it. When a candidate, terminates their registration, they're no longer running for office. We do not look at those reports. I mean, those are termination. We don't have jurisdiction over those reports.
Okay, so basically then the discovery. So any violation or any prosecution by the Campaign Spending Commission then terminates upon the dissolution of the candidate committee?
Upon satisfaction of the terms of the statute, yes. If the candidate committee qualifies or non-candidate committee qualifies for termination, yeah, we will terminate their registration.
So, I mean, a lot of times, and you know this, Kristen. I mean, I'm sorry, Miss Izumi Naito, and I apologize. I don't mean to disrespect you. Okay, it's a lot of times, and you know this, the violations are unintentional, and usually, and most violations really occur by new candidates who don't know what's occurring. I understand, I fully understand the misreporting and the intentional, and those people should, we should throw the hammer down on them. But for a lot of our treasurers are all volunteers. And even if they watch the videos, and you know this, I mean, there's a difference between ActBlue reporting versus PayPal reporting versus actual deposits. They are violations. Do they then, I mean, do these violations then become something that, and I guess will haunt the candidate forever, so long as their campaign committee is still around?
Well, I mean,
if we pass this bill.
so my comment to that is the law basically says when you file your report, you're filing that it's true and accurate. You're certifying that.
Yeah.
So the public, as well as the commission, should appreciate the fact that you're certifying the truth and accuracy of that report. If we find out later that it was inaccurate, well, then the next thing we have to look at was the misreporting intentional, knowing, or reckless? And if it falls into that area, again, that's for the commission to decide whether that matter will be referred criminally for prosecution. That's the only point. I can tell this committee that there's been very few cases that we have referred for criminal prosecution. Most have been handled through some type of administrative civil fines. So any insertion of a state of mind into an administrative agency regulation is troubling for us because we don't deal with criminal law. We have to refer that for criminal prosecution. So the state of mind, this should be more, there's a report that was filed. We can subpoena bank records. If they don't match, there's a problem. And for the most part, it's a violation. And what we'd rather do is get compliance, fix a mistake. But if it is an ongoing violation, well, then does this rise to the level intentionally, knowingly, or recklessly? That's a matter for the commission to take up. But we can't just refer something criminally, unless, but there's a few things in our statute that says is a crime. But again, our commission can't pursue it. We'd have to give it to a prosecutor to handle.
This particular bill, though, refers to violations, and that's the problem I have. If it refers to criminal prosecution, or it refers to the intentional knowing, then I have no problem with this whole discovery thing. But it's those minutia that I have problems with. So thank you very much.
Board members, other questions? Yeah, I have a couple of questions. Oh, actually, I'm sorry, before we do that, I think there's somebody else on on Zoom who would like to testify? Oh, Mr. Masakian, if you could let us take this testifier. Go ahead, Mr. Masakian. Good morning.
Aloha, good morning, everyone. Greg Misakian. I'll be very, very quick. I just jumped in from another hearing. So I do support this bill, and just so you can move along, for all, for full disclosure, I do serve on the Good Government Caucus, and we are actually Kukua Council, where I serve as president, and I'm here as an individual today, but we're going to be hosting the Good Government Caucus on Monday for a program. So we're going to be talking about different aspects of ethics and different things going on within our legislature. But I do support this measure, and I hope you move it forward. Mahalo.
Thank you. Well, I guess I'll ask you, anyone else wish to testify on HB 1520? Okay, seeing none. I do have a question for Executive Director. So I'm just reading from the bill itself. Prosecution for violations of this part shall not commence after 5 years have elapsed from the date of and then we changed it to discovery of the offense. So I guess just in terms of the underlying, and there's a variety of things that could be the underlying offense, right? It could be as simple as not filing your report on time.
I suppose so, yeah.
Okay. But the prosecution, I guess I had read it at prosecution, meaning like an actual prosecution, a criminal prosecution, that maybe derived from something like that, but that had gone well beyond the point of just missing your deadline.
Absolutely. Well, I mean, late reports is one thing, and this really addresses quite another type of offense that's covered by the, campaign spending laws. For instance, false names, when you give a false name rather than.
Well, that's a Class C felony already, correct?
It is a Class C felony already, correct. And that's why too, when these bills were coming down, we had to be very careful with the criminal statutes too, because there's some confusion as to what would be the statute of limitations for a campaign finance violation versus what would be the statute of limitations within the criminal statutes. As you've already had many hearings on the bribery statutes too, where there's some element of a public official or an elected official or a campaign spending component to it. There's just varying statute of limitations here. We're advocating the 5 years from the date of discovery because that is really typically what has happened. There have been some cases that we have had that we couldn't pursue because that report had been filed, let's just say, could be filed 5 years ago, and we can't pursue it because
okay, so but you're looking at the underlying infraction, whatever it was, but it's not necessarily criminal to start with. There are many of them would be, probably most 90% of them would be resolved, probably more than that. The vast majority of them would be resolved administratively, and it would never get to a criminal prosecution.
Correct.
But that's the moment you're talking about is the initial violation.
Correct. Yes.
Okay. So then is there a separate statute of limitations for the administrative side of things? If you don't, I mean, I'm not quite sure how it's like, how does it work now? So if you find something fairly trivial, but you don't find it in, say, this is, to me, is probably the most trivial because it happens all the time. And in our mandatory penalties, if you miss your deadline,
you mean you don't file your report on time?
Right. If you don't file your report on time,
Yes.
it's just like a $200 penalty, no matter what.
Yeah.
So if you found out 5 years, if you found out 5 years and a month from now that somebody had filed their report late,
that won't happen because we track everybody.
Okay, better use a different example. So something else that's fairly minor that is typically a mistake.
Notice of filing of fundraiser. They usually don't find that.
So let's just leave it general because I'm not sure exactly where it's going to come up. So
Yeah.
Something that's fairly minor, and you find out 5 years and a month after it happened, then are your administrative remedies also precluded? So you can't fine them $50 for whatever it was, or
Well, I mean, I guess I can say this is we don't, I mean, we do our best with our staffing to handle those types of offenses quickly. We review the reports and we can see that there was no fundraiser.
But if you didn't catch it for more than 5 years, what would happen? Are your administrative penalties precluded at that point?
No, I don't believe they are. But again, I mean, the general premise of what we do is we want good reports so that the public knows, has
Yeah,
informed
no,
voting. So we
I
wouldn't.
understand that,
Yeah.
but that's not what we're talking about here. We're talking about how long you have to bring whatever action you bring. So you're saying then that right now you believe you can bring an administrative penalty 20 years later if the
No,
person is still in office?
I think if we did that, I think we would be troubled by that as administratively as well, the staleness of that. But I mean, if it was if we found out later, I mean, let me just say this, it's public. When we dealt with Kaniela Ng, we didn't realize he had changed his bank account 5 times. We had had to subpoena many different banks to figure this out, and every single report he filed was wrong. So if we have something like this, are you going to, I mean, technically, are we going to be barred from bringing the whole campaign structure down because we just discovered it now? And that was just because everything reported to us was wrong. I mean, so that's more of an extreme example,
You're
but
still not answering my question though, because I just want to know what your statute of limitations is for the
we don't
administrative
have,
side.
to my knowledge, we don't have one for administrative, as far as violations for administratively.
So the statute of limitations that's in the current statute, not this bill, but just in the current statute. You're saying that the only thing that applies to is the actual I mean, it says prosecution, but in this case, that would imply that it means a criminal prosecution.
That's how we had interpreted
Have
it.
you interpreted it?
Yes.
Yeah, okay. All right, but it doesn't actually. So, okay. All right, other questions, members? So if we changed it to criminal prosecution for violations of this part, would that bother you?
No, I mean, again, I think the structure of this bill has to do with criminal prosecution.
Okay, so if we make that explicit, it's okay.
Yes.
Okay. All right, thank you. Other questions, members? Thank you very much. Thanks for being here. Next up is HB. HB 1548 relating to sentencing limits the maximum term of imprisonment for misdemeanors or for offenses punishable by up to or not exceeding 1 year to 364 days, allows individuals previously sentenced to a 1-year term of imprisonment to apply to the court for a sentence modification to conform to the new limit. Okay, first up on 1548 is Haley Chang for the Office of Public Defender. Good morning.
Good morning, Chair, Vice Chair, and members of the committee. The Office of the Public Defender strongly supports this measure. What it does in practice is reduce the maximum sentence to 364 days and specifies that as a 1-year penalty, essentially for misdemeanors. This has significant consequences for our clients who are non-citizens, who are facing potential immigration consequences. We believe that it does not in any way diminish the court's capacity or the system's capacity to appropriately punish those who may be in need of a year sentence, as it just diminishes it by 1 day. There are immigration attorneys who can probably tell the committee more about the minutia of how this works in practice. But I can tell you from the perspective of the Office of the Public Defenders, if something like this was in place, it would definitely lead to quicker an easier resolution of matters, because oftentimes we are under our obligations as criminal attorneys required to litigate things in order to investigate and fully flesh out all of the immigration consequences for criminal matters. So thank you for the opportunity to comment. We stand in strong support. I'll be available for questions.
Great, thank you. Next up is Office of Hawaiian Affairs and Support. Liza Ryan Gill for Hawaii Coalition for Immigrant Rights on Zoom. Yes, good morning.
Good morning. Hi, Chair, Vice Chair, members of the committee. Liza Ryan Gill with the Hawaii Coalition for Immigrant Rights. Many of our coalition members are legal service providers. We put this bill forward on their behalf as we've seen a a 500% increase in detention across the country, and a nearly 300% increase here in Hawaii. The number of folks that are currently in detention have gone from an average daily census count from about 15 to 80, 81 on a daily basis here. We put this bill forward. It's a very, very tiny little tweak, but it can help our immigration attorneys that are doing pro bono work and working with the public defenders to make sure that there are not radical repercussions for a misdemeanor for many of our immigrant families here, which, as we might remember, represents about 20% of our population in Hawaii. We thank you for your attention to this. Mahalo.
Thank you. Next up is Kat Brady for the Community Alliance on Prisons. In support, Chris Caulfield for Imua Alliance, also in support. Megan Chun and Alejandro Villarino for Mercado de la Raza. In support, Stephen Munkelt for League of Women Voters of Hawaii. In support, Yvette K for Kona Indivisible. Also in support, Veronica Mendoza for Roots Reborn Maui. In support, Leilani Stacy for ACLU of Hawaii. Good morning.
Good morning, Chair, Vice Chair, members of the committee. My name is Leilani Stacy, and I'm the Immigrants' Rights Attorney at the American Civil Liberties Union of Hawaii. And we stand in strong support of this bill and the HD1 version. And we would just stand our written testimony as the Office of Public Defenders mentioned. We work closely as well with immigration practitioners, and this one-day difference really has serious consequences. And just tangibly what that means is if there is a 365-day sentence, that means that many avenues for gaining citizenship or some sort of legal status, that's 365-day either arrest or conviction will be a bar to those sorts of immigration relief. And so other states that have passed similar measures have passed without any limitations on the types of misdemeanors that would fall under this category, really because, again, there's no difference in the accountability for citizens and non-citizens. It's just the downstream consequences are so much more serious for those who are seeking some sort of legal status. So happy to take questions, and thank you for the opportunity to testify.
Thank you very much. Next up is Christina Sablon for the Legal Clinic. And in support, Christine Andrews on Zoom, maybe. Good morning.
Good morning, Chair, Vice Chair, members of the committee. I'll stand on my written testimony, and I'm available for any questions you may have. Thank you so much.
Great. Thanks very much. Next is Marsha Kimball in support. And then there's a number of more individuals in support. Does anyone else wish to testify on HB 1548 on Zoom or here? Seeing none, let's see what the total count was. 23 in support, 0 opposed, 0 comments. Members, questions? Okay, let's go and move on to the next bill. Next bill is HB 2050 relating to partial public financing of elections. This increases the expenditure limit and the amount of partial public campaign financing available for all elective offices. First up on 2050 is Office of Hawaiian Affairs. Amy Borland. Good morning.
Aloha kakahiaka, Chair, Vice Chair, members of the committee. Imi Loa Borland with the Office of Hawaiian Affairs. OHA stands on our written testimony in support with amendments. OHA supports public financing as a good government measure. However, OHA objects to the continued disparity it faces under the partial public financing law. HRS 11-423D sets the campaign expenditure limits for candidates receiving public financing using a formula that multiplies the number of voters in the last preceding general election registered to vote in the relevant voting district by a specific dollar amount. The statewide OHA trustee races receive comparable votes to the lieutenant governor races. In the 2024 general election, the 3 OHA trustee seats for Molokai, Lanai, Kauai, and OHA trustee at large all received more votes than the 2022 primary election for the lieutenant governor. As a matter of fairness and equity, OHA respectfully requests for parity with the office of lieutenant governor. Mahalo.
Thank you. Next up is Kristen Izumi Natao for Campaign Spending Commission. Good morning again.
Morning, Chair, Vice Chair, members. Kristen Izumini Tao, Executive Director, Campaign Spending Commission. This is a Campaign Spending Commission bill, so we are in support of this. As you know, it was submitted to enhance the partial public financing program, which has never been done, and it does so by increasing the maximum amount of public funds available, including significantly to OHA, the Office of Hawaiian Affairs, to qualified candidates. It also permits a downward adjustment of the minimum qualifying contributions for certain offices, as well as increases the expenditure limit for the elected offices by 20%. As this committee knows, it's the commission's attempt to boost an existing program that's mandated by the state constitution, which has not changed and whose maximum dollar amounts has not changed since 1995. So respectfully, I'm available if you have any questions.
Great, thank you. Next up is Marlene Tom, Indivisible Hawaii Statewide Network on Zoom, maybe. Good morning again.
Good morning, Marlene Tom again from Indivisible Hawaii, and we are in strong support of HB 2050, the HD1 version. As has just been stated, the current public financing funds have not been updated since 1995, so we know that they don't match the current realities of inflation. And we support this bill because by increasing the expenditure limit and adjusting the number, well, lowering the minimum required number of qualifying contributions, this will allow more candidates to participate in the program. And the companion bill to this in the Senate, SB 2528 SD1, was passed last Wednesday. So we hope this committee will forward this bill so that we can level the playing field for all candidates, so that they don't have to be constantly concerned about fundraising. Thank you for the opportunity to testify. Mahalo.
Thanks very much. Next up, we have Chris Caulfield for Imua Alliance in support. Ariana Juliet Castillo on Zoom, maybe. Good morning.
Aloha, Aria Julia Castillo, testifying in strong support of HB 2050. I've seen how difficult it can be for viable candidates to run without access to wealthy networks, especially those who've committed to not participating in Hawaii's pay-to-play culture and those who say no to corporate money. Hawaii's public financing program is one of the most important tools we have to make elections more accessible, and it's long overdue for an upgrade. The cost of running a campaign has changed significantly, and the structure has remained pretty much the same and very underutilized. I hope we can bring up the match in this version of the bill to 4-1, as is in the Senate version right now. A 4-1 match in particular has a potential to make small dollar donations truly competitive. Also respectfully suggesting an amendment that was recently passed in the Senate version to improve how the program can function in practice. Currently, candidates receive separate allocations and spending limits for the primary and the general, a pot for each one. But in reality, many candidates will only face one true competitive race, either in the primary or in the general. And if we are able to allow the option for candidates to access up to 75% of their total authorized funds and spending limit in either the primary or the general, would help make this program a little bit more practical without increasing the total amount of funding available for candidates and without increasing the cost of the program. It simply just provides some flexibility so candidates can access the resources where it's most needed. Thank you so much for your consideration.
Thank you. Next up is Gregory Masakian, also on Zoom.
No longer present, Chair.
Okay, in support. Let's see, Marcia Kimball in support. Mike Galoyo Senior in support, William Carone in support, Judge Daniel Foley in support, James Raymond in support, Johnny May Perry in opposition, Jane Aquino in support, Martha Nakajima in support. And there's a fairly long list of additional individual testifiers, most of which are in support, but the overall count is 29 in support, 2 opposed, and no comments. Would anyone else like to testify on HB 2050? If not, members' questions? Okay, let's go ahead and move on to the next bill. That will be HB 2494. This establishes factors under which officers may arrest and detain persons without a warrant for petty misdemeanors and violations, and requires officers to document the justification for the arrests. First up on HB 2494 is Michelle Acosta for the judiciary, followed by Haley Chang for the public defender. Good morning.
Morning. Morning, Chair, Vice Chair, members of the committee. The judiciary stands on its written testimony with comments. We are requesting that there be made an amendment to the date for which the judiciary will redesign the citation to July 1st, 2027. That will allow us to redesign and procure the new citations if this measure is passed. We're also requesting an amendment to the language on page 9, lines 13 to 15, which reads available options for citation resolution and options for persons unable to afford any fines or cost imposed would be included on the new citation. This measure pertains to traffic as well as petty misdemeanors. Petty misdemeanors are criminal in nature, and at the citation phase by law enforcement, there are no options at that point. So we do request that you consider these amendments.
Great.
Available for questions.
Thank you very much. Next is Haley Chang for Office of Public Defender. Good morning again. Followed by Mark Tom for Attorney General's Office.
And good morning again. The Office of the Public Defender strongly supports this measure. We believe that the language of the bill gives law enforcement enough discretion to arrest when necessary. And we've outlined in our written testimony all of the other policy reasons and systemic reasons why we believe this is critical. We also believe this effectuates the findings of the pretrial task force as referenced in the preamble of the bill. I also just wanted to highlight the importance of revamping our citation system, which I think is equally a critical part of this measure. We have, in our capacity as the Public Defender's Office, we see countless clients who receive citations, many times that are illegible, where the court date that is a summons is not readable, resulting in bench warrants or missed appearances. And we understand that the law enforcement officers are trying to be swift and timely and efficient. But I think having a electronic system would alleviate a lot of that as well. So we stand in support of the measure. I'll be available for questions.
Thank you very much. Next is Mark Tom, Deputy Attorney General, or someone else.
Not Mark.
Good morning.
Good morning, Chair, Vice Chair, members of the committee. My name is Michelle Puhu. I'm a Deputy Attorney General. I'm actually the Supervisor of the Criminal Justice Division for the department. We are testifying in opposition to this bill. We believe that it is imperative that law enforcement maintain officer discretion to the maximum extent possible, even in petty misdemeanor cases. Essentially, this will cause every petty misdemeanor arrest to be subject to challenge by way of motion. That will mean every arrest and every piece of evidence and every confession, every statement made by a defendant who is arrested will be subject to suppression. Every arrest will be subject to challenge. And that is a problem. If a petty misdemeanant is arrested with, say, a firearm, that will be subject to suppression. The criteria that would be considered satisfactory evidence of identification, whether or not they will appear in court, an outstanding warrant, and the language in the bill gives indication the person might fail to appear. They've already given very clear indication they will not appear in court by way of that contempt arrest being on their record. Whether or not there will be further contact on the date of the incident or immediate future, These are all issues that are going to be litigated by way of motion for every petty misdemeanor arrest. And the offenses that are not laid out, in addition to driving under the influence of alcohol or petty misdemeanor abuse, harassment, disorderly conduct, theft in the fourth degree, criminal property damage, trespass second, indecent exposure, and contempt of court. The threshold for a theft 4 is $250. Criminal property damage, $500 or less. Unable to arrest unless you can meet these criteria. That is critically problem for law enforcement. We oppose this bill.
Okay, thank you. Next up is Aaron Harbinson for the judiciary with comments. Sorry. Oh, you're here. I'm sorry. Couldn't see you back there. Come on up. Good morning. Oh, I'm sorry. You just standing. Did you just want to stand on your testimony?
Yes.
Okay, sorry. With comments. Sorry. Office of Hawaiian Affairs in support. Hawaii Correctional System Oversight Commission with comments. Melissa Pavlicek for State of Hawaii Organization of Police Officers in opposition. Daniel Hugo from Department of the Prosecuting Attorney of the City and County. Also in opposition. Kelvin Walton for the Prosecuting Attorney for Hawaii County. On Zoom, maybe?
Not present, Chair.
In opposition, Andre Peters for the Honolulu Police Department. On Zoom, maybe? Oh, you're here. Come on up. Morning.
Good morning, Chair and Vice Chair and members. I'm not Andre Peters, but I'm Captain Diamonds. Andre Peters couldn't be here today. We stand by our testimony, but we acknowledge that officers have discretion currently to write citations or arrest. I think the measure should be they may issue a citation instead of shall. So that's so we oppose the bill.
Okay, thank you.
Thank you.
Next up is Maui prosecutors. Also in opposition, Rebecca Leakey for the County of Kauai prosecutor. In opposition, Stephen Donoho for Kohala Coast Resort Association. In opposition, Tammy LaFlame testifying for Fairmont Orchid. In opposition, Lars Troutman for the Policing Project at NYU School of Law and support. Captain Nicholas Angel for Hawaii Police Department in opposition. Hawaii Police Department in opposition, Jerry Gibson for Hawaii Hotel Alliance. In opposition, Lieutenant Diane Goldstein, Executive Director for Law Enforcement Action Partnership in support. Josh Frost for ACLU of Hawaii. In support, Dennis Dunn on Zoom, maybe. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard. Dennis Dunn testifying in opposition to this measure, and I'll just try to basically summarize my main points. Very similar to the objections of the Attorney General's office. Number one, this creates dangerous barriers to necessary law enforcement. If anything, over the years, I've heard victims complain that arrests are not made in situations which they are in danger. Even though it may be called a petty misdemeanor, many of these situations could involve attempted assaults or attempted sexual assaults, which may not meet that criteria, but have all the same elements. The new procedural requirements will undoubtedly lead to improper case dismissals. By setting up arbitrary legal requirements, you're inviting collateral legal challenges based solely on technical defects rather than the merits of the case. Again, as was echoing some of the comments of other testifiers in opposing this, you're going to be having unnecessary litigation over these cases simply because you're inserting new requirements that are not necessary. And then just finally, I had one other important point, and that is when you have someone that's done via citation, it may not appear on their criminal records because criminal offenses that are not supported by fingerprints will generally not be permitted to be filed with many of the criminal history databases. So in summation, I think this is a mistake. It creates a problem for police officers and for victims, and I would urge that you hold this measure. Thank you.
Thank you. Next up is William Caron in support, Lois Kim in support, Veronica Moore in support. That's everybody who signed up on SB 2494. Would anyone else like to testify on SB 2494? Okay, seeing none, members' questions. I have a question for blanking on your last name, Michelle Acosta. Ooh, I was way off. Okay, sorry.
That was a judiciary lady.
Sorry.
I think we're both Michelle's.
Is that what it is?
That's
Oh,
the
okay.
judiciary lady.
So let's see, what was my question? Yeah, so I mean, right now, under current law, under 803-6, arrest how made, there is a provision. Find it. Yeah, in the subsection B, in any case in which it is lawful for a police officer to arrest a person without a warrant for a misdemeanor, petty misdemeanor violation, the police officer may, but need not, issue a citation in lieu of the requirements of subsection A. So it's already an option. So why would this create more litigation?
Because, sir, if you continue to read in the bill on page 7, subsection C, line 8, it reads, for a petty misdemeanor, police officer shall issue a citation.
Except there's a bunch of exceptions.
Right, the exceptions that are listed in the previous section, but if you don't meet those 5 criteria, then you shall issue a citation.
Right, but that doesn't change the fact that there's still a citation for a crime and that the person is still required to show up in court and be tried for the crime or plead or whatever happens.
Yes, but what you're doing is you're requiring an officer to merely issue a citation instead of being able to effect an arrest and remove the individual from the situation of where the crime is occurring right now. Sometimes an individual needs to be removed from that situation immediately and booked.
Okay, we're just arguing about it. That's fine, but there's a bunch of exceptions. So why, I mean, isn't there always even now under current law, arresting officers have to make a decision about if this person is basically they're going through the same checklist. It's just sort of a experiential mental checklist as opposed to what's in the statute.
It is, sir, but if the statute isn't codified, then an officer can run through the statute, these checklists essentially mentally, and they're not necessarily beholden to what's actually codified in law and having to demonstrate which subsection under this statute they decided to arrest under. And this was the category that they held under in effecting the arrest. And when you do that, you're requiring the police officer to substantiate that in court later at a motion hearing, that this was the reason because of a safety issue, because of a threat issue, because of a, we thought we would have to come back immediately issue.
I understand. So, but the motion would not have anything to do with the underlying crime. It would have to do as to whether or not the person had been arrested.
Correct. And any evidence gleaned from that arrest would be subject to suppression, as well as the arrest would be subject, therefore, to dismissal.
What would be suppressed if you hadn't arrested him?
If there are any fruits of crime on the person upon the arrest, drugs, weapons, a gun, all of that would be subject to suppression because of it would be characterized as an illegal arrest. And also, if you're just issuing a citation, that person is not going through the booking procedure.
So that's what happens now if a police officer issues a citation?
No.
They're still allowed to do that, right?
Correct. But if
so you're arguing about whether the discretion that the officer has and now be restricted. They will still have discretion under this bill, but it will be restricted compared to what it is now. And you're saying that all this evil will follow from that.
Because it's codified law, sir.
Well, it's codified now that
It's-
they can arrest them with a citation, or when they can issue a citation instead of arrest.
Yes, but once you put the categories in the statute as the bases for why they cannot effect an arrest, these become things that they have to establish as to why they did the arrest.
Okay.
That's the difference.
Understood. Questions, other questions? If not, I think that was the last. Thank you very much. Yeah, let's if everybody's, let's see, what time is it? 10:48. I think we have time to vote. Right here. All right, I'll throw that all through. Okay. Okay, we've already voted on GM 573 for the statewide elections accessibility needs advisor committee. So we'll move on to HB 2095. This is the judiciary's supplemental budget for the year. Recommendation here is to pass with some amendments. Okay, so the first one, we'd like to restore the transfer from special funds to A funds, the funds for two positions redescribed for cybersecurity positions, and that would restore the judiciary's request for $188,880 in general funds for cybersecurity position, and the transfer from special funds to general funds for another position. Okay, we'll put a different effective date on it, March 22, 2075. We'll note in the committee report that it is the committee's understanding that the bill's funding for the building of a new courthouse in South Kona reflects phase one of the project, and that the additional funding will be provided in a subsequent bill for phase two. The security services funding requested by the judiciary, and then separately in the CR will indicate that the security services funding requested by the judiciary for private security guards is intended to be a temporary remedy and not a decision to permanently outsource security services. Let's see. So we're going to also add a blank appropriation to increase the contract prices for existing purchase of service contracts or services provided by community-based organizations. And we will request in the committee report that the need for the private security is reevaluated before the beginning of the 27-28 fiscal year. That will be in the committee report. Okay, questions or concerns? If not, Vice Chair for the vote.
On HB 2095, HD2, Chair's recommendations to pass with amendments. Chair Rhodes?
Aye.
Vice Chair votes aye. Senator Chang? Aye. Senator San Bonaventura?
Aye.
Senator Hawa?
Aye.
Measures adopted.
Thank you. Next up is HB 1520. This clarifies that the 5-year statute of limitations for criminal prosecutions of campaign finance violations begins upon discovery of the offense. Recommendation here is to pass with an amendment. As we mentioned during the discussion, we'll go ahead and put in the where it says prosecution, we'll just put in criminal prosecution. I think it's redundant because the whole section is about criminal prosecution, so we'll put that in. And we'll also change the bad date to another bad date, March 22, 2075. Okay, questions or concerns? If not, Senator Gabbard.
On HB 1520, HD1, Chair's recommendation is to pass with amendments. With all members present, are there any no votes or reservations?
Reservations.
Reservations for Senator San Buenaventura. Measures adopted.
Okay, thank you. Next up is HB 1548. This limits the maximum term of imprisonment for misdemeanors or for offenses punishable by up to or not exceeding 1 year to 364 days. Recommendation here is to pass with some amendments. I'm going to ask that we conform the bill to the I think it was actually a companion bill, SB 2731, and limit the offenses that this applies to those that, to limit it to violent offenses, and crimes of violence are defined in HRS 134-1. And see. And I think we'll go ahead and put a different effective date on it, March 22, 2075. So limiting it to violent offenses and a different effective date. Questions or concerns?
Yes.
Sure, go ahead.
So violent offenses, you're gonna change the sentence to 364 days?
I'm sorry, did I say it backwards?
Yeah.
I mean, yeah, okay. If I said it backwards, I'm
Non-violent.
applying this to non-violent
That
offenses.
makes more.
But the definition is in 134.1, and that's where the violent offenses are. So that's how you differentiate.
Thank you for the clarification.
Yes, it needed it. Thank you. Any other concerns? If not, Senator Gabbard.
On HB 1548 HD1 and recommendations to pass with amendments, all members present, any no votes or reservations?
No.
No vote for Senator Owa. The measure is adopted.
Okay, thank you. Next up is HB 2050. This increases the expenditure limit and the amount of partial public financing available for all elective offices under the partial public financing system that's constitutionally required by the Hawaii Constitution. Recommendation here is to increase the match of public funds in section 4 to 4-to-1, meaning $4 for every dollar raised up to the maximum amount of public funds. Correspondingly, we'll increase the maximum amount of public funds available in section 3 to 20% for the offices listed in paragraph 1 on page 4. That's governor, lieutenant governor, Honolulu mayor, and Hawaii County mayor. The current share is 10%, and the CSC proposal was 12.5. We'll raise it to 25% for the officers listed in paragraph 2 on page 4. That's senator, representative, county council, prosecuting attorney, Kauai mayor, and Maui mayor. And the current statute is 15. The CSC proposal is 18.75. Because OHA is getting a huge increase already in this bill, I'm just going to leave the 7.5 for OHA candidates, and we'll see how that goes at conference, or if it gets that, if it makes it that far. And we'll make it effective on March 22, 2025. In the CR, we'll request $3 million in appropriations to the Hawaii Election Campaign Fund, which, in addition to the amount of money that's already there, should be able to run this fund for a cycle. Questions or concerns? If not, Senator Gabbard.
On HB 2050, HD1, Chair's recommendations to pass with amendments. Any no votes or reservations? Hearing none, the measure is adopted.
Okay, thank you. Next up is HB 2494. This establishes factors under which officers may arrest and detain persons without a warrant for petty misdemeanors and violations, and requires officers to document the justification for the arrests. Recommendation here is to pass with some amendments. So we'll make it so that the citation must be visible on an offender's criminal record, which is what we had done with the the Senate companion, and noting that the last 4 digits of the Social Security number are still required, which the original bill didn't. Will require the new form be developed by January 1, 2028 per judiciary's testimony. We'll make the bill effective upon March 22, 2075. And we'll amend item 13 on page 9 to apply to citations for non-crimes, for example, violations and infractions, as crimes cannot be resolved before arraignment. And it's also from the judiciary's testimony. So it does have a bad date, and we'll like to continue the conversation about this. Questions or concerns? If not, Senator Gabbard.
On HB 2494 HD1, recommendations to pass with amendments. Any no votes or reservations? Hearing none.
No, sorry.
No vote
2494.
for Senator Owa.
Yes, 2494.
Measures adopted.
All right, thank you everyone for being here. We are adjourned. Oh, I'm sorry. Oh, I'm sorry. We have another DM. Yeah, I forgot. Well, we'll gavel out of this and okay, going in for our decision-making only agenda on House Bill 2250. This makes appropriations for claims against the state, its officers, and employees. Recommendation here is to pass with some amendments. I'm going to ask the committee to do something fairly unusual. We're going to add a couple of blank appropriations. One for Elvin Jardine for the, I'll have to back up a little bit. The current statute says that if you're deemed to be actually innocent, or found to be actually innocent under 661B, you're supposed to get $50,000 for every year that you were in prison. A settlement that was reached with Jardine after fighting over it for 9 years and going up to the Supreme Court and coming back down was for $600,000, which
less than this.
which is way less than the million. So I'm going to put in a blank appropriation and put in the CR that we suggest that we're under an obligation to follow the statute, and that there should be an additional $400,000 awarded to Jardine's heirs because he passed away before he was able to get the money. And then we'll put in two more blank appropriations for interest for the almost 10-year delay on the payment for Jardine, and then another one for Royns Durrell for interest due to this. It was not 9 years, but it was several years between the time he was exonerated and the time the claim was completed. In his case, he did get the amount that was specified by the statute. The other thing I would like to do, and I realize this is a claims against the state bill, but I'd like to incorporate the statutory amendments to the claims statute that are in SB 2311 that would prohibit claims for refunds, reimbursements, or other payments authorization for which is sought from the legislature that exceed the time limitations of section 40-68 from being claimed. And this would also require the Attorney General to submit a confidential report within 5 days after the opening of a regular session to the Speaker of the House, President of the Senate, the House and Senate Judiciary Chairs, that provides a good faith estimate of each possible judgment against the state that has not yet been settled. So it'll be confidential, so it won't affect the litigation, but it would be useful for the legislature to know what's coming down the pike. And then we'll require the Attorney General to submit a report every 5 years to the legislature containing further incidents that occurred in an agency that led to claims, so we can see whether the corrective actions that the agencies are supposed to be taking on the AG's advice are actually working. And then we'll change the effective date to March 22, 2075. Yes, and finally, I'd like to delete the US EPA claim with committee language asking the Attorney General to justify the Ways and Means Committee why it should be put back. It seems to us that the claim should be against the lessee who put in this gigantic cesspool, and I'm not sure why we're on the hook for it, but in the interest of moving the bill along by the deadline, I'd like to kick it down the road to WHAM and let them take a look at it again. All right. Any questions or concerns about any of that? If not, Senator Gabbard.
On HB 2250 HD2, recommendation is to pass with amendments. Any no votes or reservations? Hearing none, the measure is adopted.
Thank you very much. Now we're secondly adjourned.